This meeting, it says now this meeting is being recorded. All right. Great. Well, good afternoon, all. And I assume that a few folks will still draggle in. If they had anything like I did, a couple of hearings right beforehand. This is a combined section with the unbundled section, the family law section, with special invite of members of the ADR, Alternative Dispute Resolution section of the Alaska Bar Exam. And with us we have this afternoon, I hope to, at the end, you'll agree, a rather special presentation that so often it's lawyers presenting information. Today we are focusing on what some of you may have some vague information about, others may have even been former members, but for a few and some it might be totally new. For any of those three categories, we're presenting this afternoon the status of the Alaska Association of Collaborative Professionals, or AKACP, although I think we use different acronyms sometimes on that. And just a preliminary matter for anyone who's on our Zoom, that's great. Please put on mute so we don't have ambient noise. Someone is.
Lisa, Valerie, and Ryan, you do have the ability to scroll over somebody and mute them.
Okay. I will just say there's so many, I don't know who's has the challenge.
You've been waiting for?
Yes, idiots they finally resent it.
You know, I think on the, if you open the participant list, little icon will be making movement if there's noise there. That's how I figure out who to shoo away. So. All
right, my apologies to the group for this kind of admin stuff. Lisa, are you able to navigate that and maybe take care of that while I do the intros? As co-host? Oh, you're on mute.
Including myself. I've been muting people that weren't muted, including myself.
All right, so we're going to move forward here. It sounds like we've got, again, anyone who's not intending to speak, please mute. And obviously we want to invite as discussion ensues. But for the first part, we're going to do introductions of our two non-lawyer presenters who member in the Alaska Association of Collaborative Professionals, again, AKACP. Our first is Valerie Demming, who will give her a little bit professional background of herself. She's been a longtime member of AKACP and currently our singular, what we call facilitator. And she'll explain more what that term means and how it applies within the collaborative law model and what I refer to as the collaborative with a capital C. Also, Lisa Rogers, who is, I hope for many here, a well-known and familiar tax professional CPA. CPA, is that correct, Lisa? Yes. Okay.
Yes.
Who has also, again, long membered in AKACP, has been a valuable member on what we call the financial facilitator role. And then myself, I'll be the at least main, and I invite those who may be also here members of the attorney side of.
I think
all the way to the bottom.
I think the
I'm the attorney member for this meeting, but I believe we might have others, and we're going to join in on that conversation. So the goal here is to basically give an update on where Alaska Association of Collaborative Alaska Collaborative Association lands right now, give insights into how it works, the nuts and bolts of that process, and again, the lens from the three different perspectives. And there are different lenses from those professions of Valerie, Lisa, and the attorney side. And then we're going to pivot into ethics, hopefully fairly specific, discrete ethics elements from the code for attorneys. And I'll more or less herd the cats on that. But again, open forum for discussion on the ethics elements. But I'll also give you, again, my, I guess, insights as a lawyer working now many years in the collaborative law model. So with that, Valerie, if you could start your side of the presentation.
Yes, thanks, Ryan. All right, like Ryan said, my name is Dr. Valerie Ann Demming. Professionally, I have a master's in counseling and school counseling and a doctorate in psychology. I'm entering, unbelievably, my 32nd year in private practice, seeing clients. I did see young clients down to the age of 5, but I see adolescents and adults now specifically. I did have 10 years as an elementary school counselor. I live in Fairbanks and was a school counselor up here, and then also 12 years as an elementary school teacher. So I've been working with folks since 1974. And I actually looked up, I save all my calendars, and I looked up today how long I've been associated with collaborative divorce, and it's been 13 years as a mental health professional facilitator. And when I joined collaborative divorce, I had to accept what we call a paradigm shift, from being a one person in the office working with one client or a family. And now, as a collaborative team member, I am a member of a team. I'm responsible for many different aspects of a process that include 5 different people than myself. So if you can kind of think about your paradigm where you spend most of your professional life, and kind of today during the presentation, kind of open it up to be able to see how we work as a collaborative team. Each one of us has our own responsibilities as part of the team, but we work together as a unit. I'm going to share an analogy, and so hopefully that will help kind of get a focus for you on what we do. So I like to see the collaborative process like a charter airplane service. So the airplane is owned by a highly trained and diverse group of professionals who have different areas of expertise and are required to operate the plane efficiently and safely. The clients that we work with, usually a couple that want to get a divorce, they want to be in a different place in their relationship. So essentially, the team is to be able to take them from point A to point B. However, they have a great deal to do with input into the flight plan. Is it going to be longer, more scenic, or is it going to be a more fast and direct route? The contents of their baggage and how many bags they carry on the plane will impact the flight. The plane may consume more fuel and slow down due to more discussion needed, emotions that may run high and need to be addressed, or unfortunately, some hidden agendas. The clients need to do their homework in a timely basis, but the clients need to keep their focus on the final goal, and the plane can fly faster. The team is at the controls the whole time. The clients don't know how to fly the plane, and that is why they hired us. As charter operators, we have all been trained in piloting the plane, so the professionals take turns at the controls and share the load. We support each other in this task as a team. There are rules mandated by our participation agreement, and neither client can take the controls or fly the plane. There may be some surprise cargo in their baggage, and as a team, we deal with that. And the team is also responsible for the maintenance of the plane, and that takes coordinated effort with communication. And the team, during the whole process, we meet and discuss the case throughout. Before what we call 6-way meetings, where all 6 of us are in attendance, And then also what we call offline, where maybe the financial person talks with the clients, or myself as the mental health professional talks with the clients individually or as a couple without the rest of the team there. The team gives feedback to each other and we discuss what we can improve on where the case is going. The clients actually own their final settlement decision making, and they also own their behavior during the process. But remember, the plane is owned by the team, and the clients step into the plane at the start of the journey and step off the plane at the end of the journey. However, we provide much better snacks than a charter airline, because at every six-way meeting, we do have snacks. Okay, now I want to explain the process that we use to go through that. I hope the analogy kind of put it in a little bit of perspective for you of how that works. So the first part of the roadmap is we set up the framework, and that's committing to the process. And this is usually where one of the clients goes to one of the collaboratively trained attorneys and says they want to use them for their divorce. And the attorneys assemble the team, call the financial people, see who can participate in that team, see if any of us have any conflicts of interest, and the team is put together. The largest part of the process is information gathering. And I know as professionals, you have clients that want to jump right to the divorce and say, this is what I want and I want it. And in this process, the team has to gather all the information, which includes parenting, if they are parents, all of the financial information, all of the legal information. Let's say they may have a prenup. And then also one of my big responsibilities is where the emotion, how has the relationship gone and what happened to that relationship and how do they need support through the divorce process. The next part of the process is that the team, we develop a shared understanding of where the folks are at. One of the things I particularly like is at the first six-way meeting is I ask the clients to bring pictures of their children to share with the team so we can have actually a physical representation of why we're actually in this process, because especially with clients with kids, we want to make sure that we do a good job so that when the process is over, these folks can actually be co-parents. And I have to say, I have actually worked with many clients where they can be positive parental role models after the divorce. And I've also been involved in a lot of couples that get a litigated divorce. And as we all know, some of them then they can't even talk to each other. The next very important part of the collaborative process is then we get to generate and evaluate options. Each client can propose an option, and then the other party can say, yes, I agree with that option. No, I do not agree with that option, or I need time to think about it. And so what we do as a team, we put that aside, write it down, make sure that we record it, and the next meeting we will bring that option up and say, okay, have you had enough time to think about that option? Do you want to tell us if you agree with it? If you don't, you still don't agree with it, or if you want to propose a new option. And then obviously the other side also gets to look at their options and propose options. And so a lot of the process, we are looking at different options. And that's where I mean that the clients get to participate in their own decision making. It isn't where the attorneys tell them what they're going to do and they have to agree to this. They get, and they both parties agree to what they want. And then we look at the options as we're nearing the end. We look at choosing the solutions. They reach an agreement, and the agreement is drawn up, and then it's presented to the judge. And usually, the judge, since both parties have agreed to everything and have already signed to it, that they do agree. The judge usually accepts the divorce proposal. I want to talk a little bit about the mental health professional's responsibility. I usually I manage the meetings. I'm also the timekeeper. I'm responsible for putting the agendas together for each meeting, usually before a 6-way meeting. The team meets. We talk about what is going to be discussed during that meeting. So the clients don't bring in a new subject that the team doesn't know anything about at the meeting. So the meeting is run very well, so everybody is apprised of the discussion points, and we all are prepared to discuss those. Like if the financial person needs to get stuff together, or if I'm going to talk about the parenting plan, that's already put together before the 6-way.
Valerie, if I could, how do you then pivot, react as the facilitator of a quote new issue, especially if it's a bomb throw issue?
Yes, good question. Usually what happens is that the team talks about it. We figure out if we can accept that, and we do at times to add that to the agenda, or if, like Ryan said, it's kind of an explosion, or we also have to decide whether it's a crisis, where like it's a parenting issue or something that has to be decided right away. A lot of times what we will do is we will discuss that issue after the meeting, or spend time as a team talking about it, and then the attorneys will talk to the clients about it, but we will take care of that. But a lot of times we don't include it in the agenda if it's not a crisis. We will put it on the agenda for the next meeting. At every meeting, minutes are taken by either of the attorneys, and then they're passed through all the other members, and they're corrected if they need to be. And then also the mental health professional is responsible to call for a break if the emotions are running high. And usually the clients go talk to their respective attorneys, and information is exchanged, and the breaks can be anywhere from 10 to 20 minutes, and then they come back and we discuss what's happened, and maybe somebody's position has changed or whatever has happened. Another responsibility for the mental health person is to make sure that everyone's doing their homework, including the attorneys, in a timely manner. And like I mentioned before, that also includes for the financial person, the financial professional neutral, because they have a lot of responsibility to gather lots of different kinds of information. One of my other responsibilities is to check in with each member of the team, see if they've got any concerns coming up, or, how are they doing with their client? Are they having issues? And and also for me to check in with the clients and how is the process going for them. I also am responsible to meet with the clients individually and also together to address the parenting plan and look at different options for them and to become together to an agreed plan to present to the team. And then if it needs to be fine-tuned, then we can do that as a team. We also may employ a child specialist if there's certain needs or areas that need to be addressed. Maybe one of the kids has special needs, or has maybe they need some therapy, and I, as the mental health person, can suggest for either of the clients to get therapy, or maybe the kids need the therapy. However, it is not the role of the mental health neutral to be a therapist in this process. My role is totally different, and I cannot be a therapist to any of the participants on the team. So a lot of the steps, it's the preparation, laying the groundwork for a successful process, understanding the needs and goals of the parties, recognizing the unique roles and contributions of each participant in the collaborative divorce process. I have to say, I have learned so much as a mental health professional about finances. There are things in the financial world I had no idea about, and I really appreciate that. And there's no way I could do the financial piece of this. So the next part is the planning, developing a clear strategic plan that guides the process towards the resolution that the clients request. And then to implement that plan effectively and ensuring that all team members collaborate towards that common goal. So as you've heard, I've used the word a lot, teamwork. The attorneys trust the neutrals, and they allow us to do our jobs, which is wonderful. And to remember that the professionals control the process. The clients control the outcome. They don't control the process, the team members do. And then also, in conclusion, I have to mention that collaborative divorce is also guided by the ethics from the International Academy of Collaborative Professionals, and also the ethics from each of our professions. My ethics include different ethical constraints than the financials and the attorneys. And then also, there is a group called My Collaborative Team that meets every Friday. They're meeting right now at 12:30 Alaska time. They meet online and they discuss different topics related to the collaborative divorce. These are professionals from all over the United States and also the world. Sometimes they pop in too. So I know attorneys, financial people, and other mental health professionals from all over the United States. A lot of folks on the East Coast, and also from California and the Midwest. And I'm able to see how their process works in their area. So it's a wonderful opportunity to be able to learn on a weekly basis about other professionals doing the same work in a different place than Alaska. And what's also wonderful about my collaborative team is that if I have a question about a team that we have going on with clients, and maybe we hit a roadblock, or I'm having trouble working out the parenting plan or whatever, I can fly that by. There's probably usually about 20 folks on this on this presentation, and we just talk, and they give me all sorts of ideas on how to approach the the issue in different ways than maybe I've even thought of. So it's a wonderful way to get different ideas from the rest of the group and have input so I can try things in a different manner. I also wanted to say, if you have any questions, please put it in the chat, and we can also answer some of those questions as we go through this presentation. So any questions from anyone, you can just ask or write in the chat about anything that I've said.
Excellent. I want to give you opportunity to highlight any book or material that you think from your, what I'll call the MHP, mental health professional facilitator lens.
Yeah, I know you have a book that you want, and Lisa has a book. I don't have any particular titles or books that I want to chat about. There is one question. What is your response to someone that says, "Why not just mediate?" Yes, why not just mediate? That is an option. However, again, I'm going to say the team. The experience of the 5 different professionals, like I've said, I've been working with folks since 1974. I have an immense amount of experience working with all sorts of different folks, and able to look at different scenarios in different ways so those clients can find out how they want to do their divorce. The next question, on average, how much does the collaborative process cost with or without kids? And does insurance typically cover Valerie's insurance? And on average, how long does the process take? Those are excellent questions. The first question I'll answer is no. Insurance is not covered in any of this because I am not a therapist. You don't have the hat as therapist in your capacity as a facilitator through the Collab process. Is that what you mean? Correct. Yeah. As a collaborative professional, it is not as a therapist. Yes, I bring all of my experience as a therapist to the process, but insurance does not cover any of that. Like I mentioned before, on the average, how long does the process take? Actually, many different. I did one process, and they didn't have any kids. They were an older couple, and it took 2 meetings. It was over in 6 months. I have also been on other teams where it takes years, where all of these extenuating circumstances where you might be on a team and maybe one person comes down, gets cancer, and we have to put the process aside for a while until those concerns are addressed. And obviously it delays the process. And so there isn't really an average. We like to shoot for at least to try to get the process over in a year. But I'm not saying that it does or that it doesn't. It just is what it is. The cost is different for, there is not a set cost, although the collaborative group is working on what we call a flat fee. We're in the process of that right now, where if a couple comes in and we're comparing the costs with kids or without kids, and depending on how fast the clients do their homework, a lot of it has to do with that. If they get that all done in a timely manner, it can cost a lot less. But the clients have an agreement with each of the professionals, and my costs may be different than the financial person's, different than the attorney's. But that's a contract between the clients and myself. And so I cannot just say how much it costs. It's all different.
Just a footnote to that flat fee idea that we're navigating currently, but not yet settled on, is it's plural. Each team member has a discrete fee for the process. It's not one pool. Great. So Valerie, anything else on your end, unless somebody, let's see, I think, and certainly somebody can pop up at any time, and certainly on the comments. But thank you, Valerie, for giving a really grounded overview on some of the, structure, and obviously some of the notions of it being non-adversarial, if we can avoid it, and some of the boundaries that help that process. So with that,
Correct.
we will go now to Lisa, who will give us, once again, that lens on from the financial professional, the role as the numbers person in this process. Lisa.
Thank you. So my name's Lisa Rogers. I'm a certified public accountant licensed here in Alaska. My firm is Rogers and Company, CPA PC. It's a very small firm, just me and 2 staff accountants. I have been working here in Anchorage in public accounting for almost 40 years. And for the last 30 years, I have helped clients with divorce, although the focus of my practice is income and estate tax planning and compliance. And when I say a compliance, that means tax returns, doing tax returns. And planning is, trying to figure out outcomes before everything's done and planning around issues. I have served as an expert witness in a variety of cases, including divorces, for over 20 years. And then I decided that the time that I spent on litigated cases as an expert witness were filling up my calendar. And it was precluding me from working on non-litigated cases, which is what I enjoyed the most. So a number of years ago, I decided that I no longer provide expert witness services. I do provide expert consulting services in some cases, and I work with folks that are in the collaborative process. Sometimes people come to me with a do-it-yourself divorce, at which point I always tell them, you're making big legal decisions when you're getting a divorce, and each of you needs to engage an attorney. I've been trained in collaborative practice and in mediation, and I joined this collaborative group in 2010. Almost all of the collaborative cases that I have been involved in were successfully resolved. And in one case, the parties decided not to divorce, and they're still married. So I'd call that a success. I really try my best to keep families out of the court system, and I really enjoy working with people who are interested in solving their own problems. So my role as a financial neutral is to help the spouses identify all of their assets. And sometimes they don't even know what assets are, and they don't really understand liabilities either. So my role is an educational role in teaching them that, yes, things like airline miles and rewards plans and lottery tickets and sometimes lawsuits in progress are potential assets. tax attributes like net operating losses, charitable contribution carryovers, passive loss carryovers, capital loss carryovers, are all assets or have the potential to be assets. And so what usually happens is that if they can do it, and usually they can, they come to my office and we sit in my conference room and I start preparing a spreadsheet with all of the assets and all the liabilities on it. And then I have a secure web portal. And so in a collaborative case, I make a portal account and give access to me, both attorneys, both clients, and the mental health professional. So everybody has access to all of the documents, and those documents sit there until the collaborative process is complete. And we can, put subfolders in, sometimes there's really a lot of documents, but I like that because, I like the fact that everybody can see everything. It makes it very transparent. And one thing that I can't do, and I tell the clients this right out of the box, I can't keep secrets. This is a collaborative process and it's transparent. So if you have questions, there's information you want to know, I can't be a private detective sleuthing things out for one party. That's not how it works. It's open. And so, understand that if you tell me things, then it's not a secret because I am a neutral, and my neutral fairy dust, if you will, only works if I'm able to remain neutral in fact and in appearance. Sometimes we bring in other financial professionals or experts of various sorts. For example, real estate appraisers, real estate brokers, business valuation specialists, pension valuation specialists, mortgage lenders, possibly if we have issues with refinancing. And if somebody's got a problem with debt, they may need to go to credit counseling or debt counseling to understand how to manage that. So we go through this process of identifying all the assets, and then we figure out how they want to value them. And with real estate, we talk about, okay, do you want an appraisal, an MAI appraisals, or do you want to use brokers' opinions of value, or do you want to go with tax assessments? And it's up to the people, up to the spouses with the advice of their attorneys. And I defer back to the attorneys a lot because all of these things have ramifications, and the attorneys, we are all on a team, but they are their client's advisor. And then I help them come up with the division, how they're going to do their property settlement. Most of the cases that I've worked on do not have children. Most of the cases that I've worked on are gray divorces, but there are exceptions. And I would say, I spent some time prior to this presentation looking back on my cases. I keep a log of all my collaborative cases that I've ever done. And the cases that I thought were really best suited to the collaborative processes were cases where I had a case where one party had a diagnosed mental illness, and there was really no way that the litigation process would work for her. And through the collaborative process, they were able to, with the help of their attorneys and me, come up with a property settlement that worked. One case had really complex data separation issues. And both of them were convinced that they were right on their date of separation. And that, you know, there were just it was really complicated, but we were able to get through it. At the end of it, they asked the collaborative team to propose a property settlement, and because they, you know, they were both very good negotiators, and this process went on for a really long time. I know it was over a year. I don't remember exactly how long it went on, but it was a long time. And they finally decided, you know, we will not be able to come up with an agreement ourselves. And so we want the two attorneys and you, Lisa, to come up with a property settlement and come up with a separation date. And so we did. And they were able to finally get divorced. I've had cases where people have addiction or substance abuse issues, alcohol and other drugs. And thinking back on those, I don't think that a litigation process would work. The input of the mental health professional in suggesting that people with these problems get treatment, and actually having the spouse go through the treatment, you know, you put everything on pause while they go through their treatment so they can get those substance abuse issues under control. That's, to me, that's the real beauty of the collaborative process. I've had a case where one of the parties was religiously, adamantly opposed to divorce, and they were getting to be senior citizens. Neither one of them had any intention of remarrying. So through this process, they obtained a legal separation, and that worked. And so they were able to go on with their separate lives and get this legal separation. Before the Affordable Care Act, we always had health insurance issues, and that's not, you know, it's expensive, but it's not like people can't get health insurance at all, which used to be the case. Complex property issues, people that own businesses. The collaborative process, I think, is very well suited to really complex cases. And in my experience with litigation, with litigated divorces and having battles of expert witnesses with different values, and it just seemed to me that the process would drag out for a really long time, and that oftentimes there was really no way for the judge to really take the time to comprehend it all. So I think the collaborative process works really well for high wealth divorces with complex property issues. And then the other part about it is it's private. You know, the process is private. We figure out everything before the attorneys file the case in the court system. And so they file the case, they get the hearing scheduled, you go in, you have a 30-minute hearing, and you're done. You're done. How much time does it take? I also looked back at that, and the shortest case I found concluded in about 4 months, and the longest case took about 3 years. And I also looked at my fees, and they ranged from typically around $5,000 to $15,000, depending on the complexity, the length of time, and all the other factors. And so that is kind of what I do and how I do it. So
So
back
with-
to you, Ryan. Is
Well,
there
I'm gonna-
anything else I should
Yep,
cover?
it's gonna be it will be return served right back to you, because I want to drill into, since you framed this initially as you came from the expert in litigation, at least as part of your service, a major wedge, let's call it that, of your practice. That gives you perspective, both in terms of the cost of you as the expert and as the, we'll just call the financial hat in a divorce case. Do you have an input from the folks here, to the folks here, of net plus, net minus on the, let's just call it the pure financial cost, cost fob Lisa to do the role in litigation, let's say a complex litigation versus a complex collab, and whether there's any net advantage, disadvantage that you've perceived just organically from that. And footnote to that is not just then beyond just the pure money cost to you is the non-financial, less quantifiable comparison.
So one of the things about the litigation process is that usually there's two financial professionals. Each side has their own financial professional. Each side is preparing their own expert witness reports. Well, first of all, expert witness reports take a long time to prepare because they are going to be scrutinized so thoroughly in cross-examination that so you have this report that's taking a long time to prepare because you don't want any comma to be out of place or any decimal to be in the wrong space, or you just really try to make these expert reports perfect, which is time consuming in and of itself. When you're in a collaborative case, there's no expert report, and you're just sitting there explaining it to everybody and making spreadsheets and or whatever you need to do to flow charts, spreadsheets, whatever it is that is going to work for these people so that they understand what they're getting into. But it takes less time, and there's only one of me. I'm a financial neutral with my engagement letter, which is what accountants call contracts for services. We call them engagement letters. And one of my staff used to crack up. He says, "How can you have a divorce engagement?" I thought engagements were for weddings. So, well, we call them engagements, whatever it is we're doing. So we have divorce engagements. It's fine. But I'm a financial neutral, so I'm preparing this information for both. We're sometimes all of us sitting at the table working up the information. So the flow of information is completely dynamic. It's going in all directions all of the time. And we're all working toward one goal, which is a workable, sustainable settlement. The other thing about collaborative, I feel that's really different than litigated divorce is that because everybody was involved in coming up with the solution, they don't end up going back to court. Maybe that is the most valuable part of collaborative, is that in my experience, they don't end up going back to court over parenting issues. They don't end up going back to court over things that have to do with property or support, because they were all involved in coming up with the solution. And I think in that process learned about problem solving. And I think the spouses typically learn quite a bit about problem solving. And in more than one case, the spouses have told me, we're talking more now in a more meaningful way than we have in years. And it's in the process of getting a divorce. So is that helpful, Ryan, in your mind?
Yeah, it is. And Valerie, I bet you have a hanger to put on that from your perspective. of the impact on the spouses usually, or parents, of whether this process, at least in tendency, feeds the wrong dog in the fight, meaning the emotions being escalated versus de-escalated, and more to the point of Lisa's observation, the teaching by observation and teaching by lessons within the process.
Yes, it's so interesting for me to watch couples sit down across the table from each other with the support of the team and be able to discuss many, many topics that have stymied them for years, of being able to actually, listen and be able to state how they see things differently, but also come to a conclusion where they can agree upon all of this, all of these items. And I agree with Lisa. It's so great to be able to, watch the evolution of their communication growing and changing. So hopefully, after the divorce, that can continue, especially from my point of view, if they're parents, because that's just so important for the kids to see that role model, that, oh my gosh, mom and dad can talk about different things, and they don't, get angry and blow up at each other. And I see that as a really positive part of this process.
Thank you. And Lisa, a book or material that you want to highlight from your perspective?
You are reading my mind, Ryan. I just looked at my table and I see A Clear and Easy Guide to Collaborative Divorce by Jeremy S. Gaze. He's a doctor of psychology. And I'll go ahead and put that information in the chat. It just so happens that I have a bunch of these books that the collaborative group purchased. And so I've had this box of books in inventory, and we sell them for $10 a piece. And I've got them all in my office if you're interested. But I like the book because it has a topic on every page. For example, what happens at the first team meeting? What kind of problems can arise? How is our divorce agreement finalized? There's, each page is one question with an answer. So a person can read it quickly and dial right in from the table of contents right to the topic that they're interested in. They don't have to read the whole book.
Is that steered more for the clients or for practitioners in the Collab process, or both?
Oh, it's really geared towards clients. I think it's, because it's written at a very basic reading level. It's not technical. It's really written for clients.
Okay, well, thank you. I don't see currently any other questions, follow-ups in the chat so far. So I will then, I guess, take the reign here somewhat on giving the attorney lens. And I see we have Dorothy Aguero here, who is one of our members. We have Stefan Otterson as well. Michael Gershell could not make it, and neither could Lori Colbert. And
Actually, Lori's here.
oh, she did show?
I
Oh, I
just
apologize.
popped in, sorry.
Oh, okay, there you go. Excellent, thank you. All right. And so I just want to also give green light to any input from our existing attorney side as well. And I also want to just note as well that Rachel Bunnell is our other financial professional who comes from the what we'll call wealth management training side, and provides a lot of obviously the similar information and what I keep calling lens within the Collab process. before I dive in, just understand, and I'm sure you do, this is that proverbial 30,000 foot view on all of the topics we're tapping into this afternoon. For instance, the participation agreement that the Collab team has utilizes with participants, in other words, the husband and wife or the father, the mother, father, was probably hundreds of hours in the making, and the dissection of that and the layers. Anyone who's interested in exploring what I called in the notes for this, or the present, what I'll call the invite for this session, was the different possibility of a wedge being added to your individual practice as a lawyer who might be looking to either expand just the options for you, or really, let's say, having a less purely litigious angle to your practice. Michael Gershell provided what considered a first draft with some of his, we'll call it humor flavor, of the application handout that Lori has emailed to everyone and is on each section for you to be able to see, to get some of the basics of what it takes to at least start that process to member in the association. So with that, from the attorney's perspective, I will tell you that all the information, education, and even practicing in the alternative dispute resolution arena that I've had ever since learning, first of all, in law school, when it was mediation was known, but ADR was just becoming, I guess, a thing. And I guess by doing that, I'm portraying just how far back I go. But Willamette University, law school at that time, had its first ever certificate of dispute resolution that first year. And I plugged into that. Now, as you all know, it's one thing to learn the academics, read books, even have model or mock efforts within an academic. It's quite another to sit kneecap to kneecap with two sometimes hostile individuals, hostile toward each other, hopefully not toward the mediator or ADR practitioner, because it's the reality of hard knocks. And what I've learned through my own, the litigator side and the ADR side is that with the specifically as to the Collab part of that divide, this idea of having a team approach, somebody had put in the comments, why not mediate? Absolutely, that is a valuable tool. There's no question. And any mediators on, and I see we have several, hopefully would not look at this as either competition of or replacement for mediation. That is not the message here. Rather, this is another arrow of your legal quiver, and you can either, again, include formally in your own by associating and membering in the association by meeting the qualifications, or just being aware of it. Because as we'll see, if we get through some of the ethics elements, it's something of our duty, our obligation as legal practitioners to inform our clients of the different ways of reaching their goal within fill in the blank. And obviously my goal, or my focus, is more divorce and custody and things relating to family law. Hopefully we have practitioners who don't look at exclusively, or they have other avenues and they could look at collaborative law. Although I will tell you, collaborative law right now, our main areas are for divorce and custody cases, or obviously combined. But back to this idea of the team, that is new, or had been past tense, new for me. I had not been exposed to that at Willamette. I had not seen that played out in litigation or in other ADR formats. So when I saw many years ago through, I think it was at a state convention, the then generation of AKACP was presenting almost like a mock abbreviated meeting, 6-way meeting, I think it was, or 4-way anyway. That intrigued me. And then when one of those members approached me about membering in that, what attracted me was this organic idea of having a team approach. Now, if you're a well-honed, tenured litigator, that almost might have an automatic reaction that may not be positive. And it leads to a lot of legitimate questions that, again, overlap into the ethics issues. But this notion of having a team approach does trigger the, what's that phrase? The sum exceeding the whole of the parts. Because I don't know as a lawyer, Valerie's I don't bring to the table for my client the value of her history, of her perspective, right? Of her own war stories from the MHP side, the mental health professional side. Same thing with Lisa or Rachel Bonnell. They bring not just information and not just issue spotting, which we've covered a little bit today, but also there's this, I can't put my finger on how to quantify it for you, but there's this notion of being able to, this team approach providing, or at least the potential, provide a more holistic, and I hate that phrase because it's overused, but it applies. It's more holistic approach for the clients. I don't know how many litigators here have ever seen their clients go out to dinner after putting their settlement on the record. I never saw that as a litigator. I've seen that as a Collab lawyer through the Collab process. Now, that said, it's also not kumbaya. This is not preordained that people come in, oh, we're going to settle and we like each other and so forth, and we just need a little help getting across the goal line. No, it can be contentious, all right? And in fact, I would submit that that's in those kinds of cases where Collab, if properly administered, comes into its own. Now that takes, again, training and the team working together. Anyone interested more in that team approach, again, if we could dive down if we had more time, but really the thing to do is to maybe reach out to one of us that's in the Collab. And if you wonder who that is, just Google Alaska Collaborative Law. That will take you to the collaborative website. One drop down of that is the find a professional. And one element of that is the current lawyers. Or you can reach out to Valerie or to Lisa, whomever. Get the information, make your own informed choice. Okay, and that's either from your own, again, professional idea of expansion, or just, again, that idea of ethically providing options to clients. Pivoting then to the ethics, actually, before I go on to that, just one tagline onto this idea of the this team approach. And what allowed me to do as a practitioner is my book of reference is, and I'll see if I can show you here. It's not going to show very well, is Navigating Emotional Currents in Collaborative Divorce. And this is a book that I've taken. In fact, I think it's got, you can see some of the tabs. But what I gathered from this more than probably anything is this metaphor. Valerie used this analogy quite a bit through her presentation of the airplane, right? Mine was more about the navigating like a boat through the water and being able to have this approach that for the clients foretells and foresees ahead of time those hidden rocks in the currents, right? Because we do have this experience that we can bring to the table. And we can, Valerie, for instance, she can see a look in the eye or a turn of the face and see that we might have a problem with one of our clients. So that, frankly, most of us lawyers are willfully ill-equipped in that side of checking things. In fact, sometimes, sadly, we feed into that, don't we? So just that with that, that's my metaphor of guidance, is this idea of navigating through and being able to see, or at least quickly address those hidden rocks. And the rocks in this metaphor have to do with, again, the bombshells that clients bring into the case, or things that may happen just during the case. With that, let me turn to the ethics component here with our final roughly 25 minutes. And that allows us to have that 0.5 ethics credit. So what I did is,
Ryan, there's a
yes.
couple of
I'm
questions
sorry.
in the comments.
Okay, yep, there are. Let's see. Let me just try to go through. How much interest are you getting from clients in collaborative law? Or I should say the collaborative process. I can see the expense possibly being a barrier to people. How can I see the interest? Maybe I'll hopefully answer the first, because I'm not exactly sure in its own context what it's asking, but the second one I can. Hopefully I'll answer the both. Yeah, it's always right. Any of the options are a cost benefit analysis, right? Question for I have as a lawyer is, anybody who's concerned, not concerned, but is, let's say, pessimistic about or negatively assumptive about the quote cost of Collab compared to what? Lisa spent and gave insight from her experience as just an expert in a case, a litigation case. Everyone here who's a litigator, formerly or currently, knows that it can get out of whack financially for the clients, and a lot of times translates, frankly, into receivables that end up, let's say, making an interesting dynamic of your relationship with the client. Then we have mediators here, right? That can actually save money, and that's one valid goal. Sometimes, however, it obviously does not, but one inherent benefit cost-wise, right? You're dealing with one mediator. Here we got a team approach, so it sounds like, wow, that's going to be, quote, expensive. My view of that is this, and this comes from both just logic and experience, and that is, yes, more upfront with the goal of saving more over time. Lisa talked about, and I've seen this for sure from my lens as a lawyer, is this process, for the most part, keeps people out of court. What's the cost of that over time, over years, over motions? And that's just the money side of it, let alone we'll call it Valerie's side of the equation. So my view of this is I look at it as an investment put into the process ahead of time to get a rate of return by saving that cost over time. Hope that makes some sense. Certainly we have pushback on that, and it does not always work. That is true. But then what does? What process has 100% rate of success? I will tell you that the success rate with this association with cases is high. And to the extent we bring competence within that system, the percentage goes up.
The other thing that I would like to add, Ryan, is that a lot of the work that the financial and the mental health person does is what I mentioned before is offline, which means we meet individually with one client or both clients. And so it doesn't also take, the bottom line from the attorneys aren't there. So the clients are not paying the attorneys, they're paying one person. And so if I can get I'm not going to say when I get a parenting plan together, that costs a lot less than sitting down with the whole team and doing the parenting plan. There's no reason to sit down with the whole team to do it. I can do that with the clients and take care of that on a lot less expensive way.
Yeah, and I was going to jump in. Stefan and I just finished a case a few months ago where the clients had 9 companies. You're on mute, Stefan, but it would have been next to impossible to litigate. And most of the work was done by our financial professional putting together all the businesses and the percentages and the spreadsheets. And I mean by having one professional do that as opposed to 2 attorneys creating competing spreadsheets, trying to get business valuations, it would have been, $1 million divorce, literally. And litigation would have been just like a nightmare. And we managed to do it through the collaborative process. And so when you think about things like that, it's priceless.
Stephen, you want to add to that?
Yeah, I think the count in the total number of LLCs was closer to 20 than 10. And a lot of them were fractional owners of other LLCs. So yeah, it was complicated. And interestingly, the client who was the money person, who was most informed on these things, didn't himself know exactly, all of the details that were needed. So the financial neutral was able to develop those. And I think the couple left with a better understanding of, for the first time, probably a full understanding of their estate. Another thing about that case is it required a lot of planning. To have a post-divorce plan is a really valuable thing, and you don't get the luxury of doing that when, say, you're turning it over to a judge for a certain number of hours. Same thing with a mediator. The attorneys work up their things in their silos, and then you come together with a mediator, but you've only got so many hours. You whip out something that's, very rough, but you can agree on it. The attorneys then have to hammer out the written orders and so on. And, you're putting all your time into that, and there's no time that goes into really planning what's going to be a viable arrangement for these people after the divorce is done. In this particular case, there were, it was one of those cases where the estate is really high in assets and really low in cash. And it was very complex to figure out how to manage the cash flow post-divorce so that both of them would be able to get by and they wouldn't have to liquidate a lot of these properties that were in no state to liquidate. So, it's that kind of case where things are complicated, where, some thought is needed to generate a good quality plan, and also to, help the folks figure out how to move forward. In this case, we were able to structure it in a way that allowed them to keep all of the properties and also to co-own some of them. Not always a good idea, but in this case, enough work went into planning it out that it seemed like a reasonable thing to do. And as far as I know, it's been working out. So yeah, it's not necessarily cheap, but you are putting all your energy into the stuff that makes a difference in the long run, and you end up with a much higher quality product. You get more for your buck. And you cut out, if you look at the bell curve of what the costs are, my experience is that doing it collaboratively is not necessarily going to be cheaper. It's going to be in that same bell curve with a traditional approach, including settlement. But you're cutting out the tails of the bell curve. Yeah, it's not going to be ultra cheap, but it's not going to be a blowout expensive, out of control litigation either. You're eliminating that possibility. So that's my 2 minutes.
And Lisa, I'm going to ask you to piggyback a bit on that and kind of spark your memory, perhaps, when you were referring some time ago on the somewhat schizophrenia of seeing from, again, the outside looking in and maybe participating in that directly as the expert, but of you're trying to settle and at the same time you're prepping for trial, and the inherent inefficiency of that, just financially, but also just, again, any takeaways you have from that, again, the outside looking in on that process.
Sure. In fact, I have a placard that shows, the litigation process coming down, preparing for trial, and then it loops back up while you're trying to settle, and then you're preparing for trial and you're looping back up towards settlement. Whereas in the collaborative process, one of the key incentives to make it work is that if the process fails and the spouses decide to litigate, they cannot hire any of the professionals. So from day one, we are working toward an agreement. We are working toward a parenting plan. I don't have anything to do with parenting plans. That's Valerie's game. But we're working, my role is working toward a property settlement from day one, through a very orderly process. And when I was working as an expert witness in all those cases, I'd prepare these expert reports and they'd go over to the other side, and most of them never saw their day in court because probably over 90% of the cases that I worked on settled anyway. And I just felt like there was, and still feel like there's just an incredible amount of work that goes into these expert reports. It's really not necessary to resolve the case if you chose another method of solving it.
And I won't say that any of the blogs that are on the Alaska Collaborative Law Association website go specifically into this issue, but if somebody wants more, again, a little deeper dive into any of these subpoints, we do have some blogs and I think 1 or 2 videos on there that are available just to read at your ability and leisure to, again, get a little deeper into the ideas and thoughts and insights about being a collaborative law practitioner. And finally, I think I do understand this other question about how much interest are you getting from clients in collaborative law. I'm going to take that as how much just calls come in. I would say that's on a fits and starts, just like anybody's practice, basically. Sometimes it seems like dry for a while. Other times it pops up. One interesting difference, however, is if somebody is interested, if a person out there on a custody case, let's say, is interested, and they go to the collaborative site and maybe they'll call, I don't know, Lori. Let's say they call Lori on the list, whatever reason, right? She'll go through the rudiments of the process and the interest and so forth. And basically it becomes this effort to see, reaching out to other members of the team, of the potential team, just to marshal, again, the team, the other lawyer, even reaching out to one of the other lawyer members to see of interest in representing, let's say now the father on that side. Imagine doing that. And in fact, even having it being an ethical challenge to do that in a traditional advocacy, when I want to put a capital T on traditional advocacy role, which at least presumes the notion of possible and maybe probable litigation. The last thing you're going to do is that idea, say, well, go hire this other lawyer, right? And that's just one little footnote or example of the difference of this approach. There's a lot of others we just don't have time to go into.
The
But what
other
I do
one,
wanna-
Ryan, I want to add is that probably 3 to 4 times a year, the collaborative group also presents what we call divorce options, where it's just like an hour and a half presentation of all the different options that people have in the state of Alaska to get a divorce. Collaborative is one of those options, but we also go through mediation, litigation, and do it yourself. I mean, we talk about all of those options just as a service to the community to let people know what those options are for them to get a divorce.
I'm glad you reminded me of that, Valerie, because the Collab Association website has a notice about the next workshop, which I believe is January 23rd, if my memory serves. And this is outreach for the public to learn, but obviously you're all invited, obviously, to plug in on that. And those are Zoom presentations. Is that right? Okay, so I see nodding.
It's the 23rd at 5:15.
Okay. All right. I see no other chat requests, so I'm going to do what I can here with our ethics element. I'm just going to run through very quickly. What I did is I basically went through the code for lawyers, the RPC, I'm sorry, the RPC, Alaska Rules of Professional Conduct. I don't want to misstate it. Of which could be obvious trigger points for the collaborative law, and that could be its own couple of hour presentation, obviously. And Phil Shanahan could do much better than anything I'll do, but I just want to kind of issue spot at this stage And maybe if somebody wants to comment, especially from either the litigator side or the mediator side, in these thoughts. The first one was 1.1, rule 1.1 under competence, subsection A. And I'm sorry for not looking at the camera here. I'll be reading. A lawyer shall provide competent representation to a client. Competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for representation. Now, we all know that, both by having read that, I'm sure, before, but also just organically, right? But my point is, what does it mean? How does it translate if you're wearing your hat as collaborative lawyer? The quickie on that for me on this is that the process and the commitment of the clients to what they say when they have that first phone call with you or Zoom or whatever, that first connection where you're talking about the Collab as an option. If they are dedicated and they want what I call their bullseye, if they are focused on wanting a collaborative result, and people do that for different reasons, as we know, but if that's a focus of their result, okay, and then we take the next steps into the collaborative process and engage the operational agreement for that, that frames, in my mind, the advocacy, both in terms of my role, right, to fulfill that requirement of being properly prepared. But it also frames what we so often hear out there, they quote zealous advocacy, right? Collaborative law does not throw out the obligation to be an advocate. But in my mind, what it does is reframe the context for that advocacy, which means, in terms of nuts and bolts, we don't have formal discovery. Well, but then you're not being ethical, right? Well, wait a minute. Again, the client, and both, by the way, the ethics rules, if you go a little further down into the matter of the zealous advocacy element, it allows basically what we'll call a contract, for lack of a better phrase, a contract, an understanding between the client and the attorney of what the role is and the process that you're going to use to get to that role, to that goal. Okay. So in Collab, what we have is an operational agreement that, again, through a lot of effort, has framed what it means for the lawyer to advocate. And on the discovery side, one window for you guys is that it is full discovery. There is no formal 26.1s. You don't send out interrogatories and requests for production. You don't have depositions. Instead, you have a contract-based expectation and can be enforced within the context of the Collab process to have it honored of providing the information to the other side that you think allows not just your client to quote win, but to have that team approach succeed. Because again, back to the original idea, that was the client's stated goal. Not for everybody, but if that makes sense for that client, then that defines it. And that's why I'm very comfortable in that context ethically. Let's move on then to, just 2 points on that. Is that on turn back in terms of competence, before we move on, is that, yeah, a newbie lawyer would probably need to have some experience in some of most of the family law side, to feel comfortable, I would say, practicing as a collaborative lawyer, and which hurts some of the complexities involved and why that makes sense to meet the ethics requirements in the collaborative process. That doesn't mean you have to have 20 years experience, but it does mean bringing to the table some real experience in the nuts and bolts of family law. All right, so moving on to 1.2, scope of representation, subsection A. Let's see, I'm going to just zeroing in on the dependent clause here. Shall consult with the client as to the means by which they are to be pursued. In other words, the client's the decisions concerning the objectives of representation, and shall consult with the client as to the means by which they are to be pursued. And I just covered that earlier. This is just another means, but that rather unique means gives leeway or gives you a different definition for your role as an advocate. Subsection C of 1.2, a lawyer may limit the scope of representation if the limitation is reasonable under the circumstances and the client consents after consultation. So in a quick nutshell, that means you say what you need to say to the potential Collab client, explaining enough of the process and the alternatives for them to make what I call an informed choice. And if you've done that and the client comports with that understanding and they pick Collab, then you've met that burden under 1.2C in my mind. By the way, I'm not aware of any ethics challenges in the whatever 12 plus years, I think it's at least, the Collab has been a thing and the generations it's morphed into over time here. I'm not aware of any ethics challenge made by a client against an attorney. There may exist. I've not heard any of that organically. Okay, let's see. Let's see. I'm going to move on then, because there's comment sections, but it all goes to the same idea there. So I'm going to move on to 1.3 under diligence. And I talked about this before. This is where that zeal, that magic zeal word comes up. But interestingly, it doesn't pop up in the rule itself. It's in the commentary. But what is in the rule itself is, quote, reasonable diligence. And I'm just going to piggyback on again is that the nature of the process and the client getting on board and you as attorney thinking, okay, this person does meet what is a fit for Collab, seems to me you've met that requirement, so long as you advocate properly within that context. Not going the same as a litigator who wants to go to court and wants their sword in court. That's not forcing them or cajoling them in a Collab may not be the best fit. And that's a case-by-case issue. Let's go to the next one. There are a couple minutes to go here. We have confidentiality of information. This one would take an hour plus to really dive into, okay? And obviously a basic divide here is, wait a minute, you're giving full disclosure and you're not requiring it to be by formal discovery and so forth. Aren't you violating confidentiality? Well, first of all, the rule allows some broadness of what that means within the discretion of what the client wants to do. But secondly, our operational agreement has a provision is that the client says specifically, this is secret, this is confidential. I do not want this revealed. That still applies explicitly in our operation agreement. Now, that creates a question that might just have a gut check on whether the Collab is going to be able to be pursued or continued, depending on what the issue is that they want to keep secret. But without going to the bowels of our operational agreement, you can learn more about that by reaching out to us, of course, and we want to have you do that, any one of us. But once again, you're not putting the client under the bus. But again, this context is different than the traditional way of looking at this as a litigator, for sure. And then finally, since we're right at our time here, is I'm just going to skip the comment section that I had referenced, that I intended to reference earlier. Is let's see. I'm going to skip 1.114, client with impaired impact. That had more to do with just an anecdote that had occurred some years ago in a case I was involved with. So I'll go instead to the. Make sure I have this. So here's position of such. It's not what would come. Yeah, is. Yeah, 2.1. It's called advisor. That's the heading. 2.1. Let me just go to the clause on that one. The availability of alternative forms of dispute resolution that may be relevant to the to the client's situation. We have a rule that basically says part of your role is to give that client the alternatives. How many of us have always done that? Well, hopefully this time as we conclude here, we'll at least arm you with one of those other, what I referred to before, arrows in your litigation quiver, to at least help clients that you have make an informed choice about their options. And then finally, as professionals, give you potentially another option. And we once again open door for you to reach out to any of our members listed on the Collab website. And with that, we are at 1:30. Appreciate all of your participation. And I just want to finally, I apologize to Katie Sutton, who wanted to give just a little plug about ADSFA. They've got it's a course or a class coming on. So if you're still on, and I apologize, I've got too many names here. Did you want to give a little plug for ADSFA? I think she might have had to leave. I don't see her listed. certainly go to their website. She also put a PDF here. I don't know if it went just to me. It looks like a direct message. I'll see about having that populated out by Lynn to everyone. I apologize for just running out of time. So with that, thank you for your participation on behalf of the Unbundled section, Family Law section, and again, the invite to the ADARA section. With that, we're done.
And Brian, can I just
Yes.
jump in?
Yes.
I just looked up when the next remote collaborative, the basic training is. And it looks like there's one starting on February 25th. And I put a link in the comments.
Yeah, because one tripwire of membering is to have an initial certification class of some kind that's available either in Alaska or more likely outside for getting grounded in collaborative law. Thank you all.
And Ryan, if anyone's interested in the ANSFA training, it's March 5th. And the family law section members did receive a flyer this week from Lynn from the Bar Association.
I had seen it myself, but she wanted to highlight it and I just ran out of time.
It's
Thank
a
you,
great
though.
training for new lawyers. So
Good point. And maybe that should be a highlight to send to the new lawyers section.
Mhm.
Okay. I think we're done and I've got to hit the end record button and find that puppy before, but with that, you are free to go for your Friday afternoon. And Lisa, apologize. Stay on if you would, Lisa. Maybe help me find that stop record button. Shoot.